Hello, this is Rick Vatner from ESTV. I'm here with John Tamplin from Solutions in the Workplace, and we're at the Edgecliff Surfaced Offices in Edgecliff, talking about industrial relations. And in fact, I think we've really got on to microeconomic reform and where we're going with it. And so far, from what you've said, there are a number of things which are carrying through, which I actually thought were being thrown out. I thought that when the Labor government got voted in, their policy was so totally different to the Liberals. That's why the Liberals basically were so against it.
Well, not really, Rick. Both parties have agreed on the veracity of microeconomic reform and its necessity for the economy and for companies' operations. But unfortunately, I'll step back a bit. Prior to work choices, if the employer and employee reached agreement on terms of an agreement, they would file it with the Australian Industrial Relations Commission. And the Australian Industrial Relations Commission would review the terms of the agreement, assess it as against the no disadvantage test overall, and then within approximately 21 days they would certify the agreement and it would become law. And the employer and employee could then rely upon it and know that it was enforceable against both parties.
Right. And then the Howard government introduced work choices.
Choices, yes.
And something changed then.
Yeah, well, the changes that occurred then have continued under the Labor government, and are going to continue as of the 1st of July under the Fair Work Australia.
And what are they?
Well, what happens is, for some reason, somebody took a bent against the Australian Industrial Relations Commission, and they set up what was the Workplace Ombudsman and the Workplace Authority.
This is to replace
the Australian Industrial Relations Commission,
right,
for the purposes of making agreements. So the employer and the employee would agree on the terms of the agreement, file it,
right,
and then it became law the moment they got a note back from the authority saying we've received it.
All right. And then it took 21 days for it to get approved.
No. It then goes off into the ether. Now the same system operates now, and it will operate under Fair Work Australia. We have agreements that have been there for 10 months, and we don't know whether they've passed the no disadvantage test.
These are the same agreements that would have got approved in 21 days under the
Australian Industrial Relations Commission.
So firstly, what's taking them so long now? And secondly, what happens if 10 months or even longer down the track that agreement is not approved?
Well, let's do it with the second part first. If it is not approved, then the employer has to make up the whatever disadvantage the employee suffered as against the award, back pay for approximately 10 months. And they can be prosecuted. The finalisation of the no disadvantage test is taking so long that it works against microeconomic reform. For example, an employer is taking a significant risk by entering an agreement and putting it into the Workplace Authority. I'll give you an example, because we've written to Minister Gillard on the matter on several occasions. Between 28 March and 31 December
2008,
there were 97,000 agreements filed with the Workplace Authority. Of those 97,000, 39,000 have been processed. All the rest are in limbo.
So that's approximately a third have been approved. Now, these are the same 97,000 that, had they been submitted to the Industrial Relations Tribunal, they would have been approved within 21 days.
Thereabouts.
So, John, before we finish, why is it taking so much longer all of a sudden?
It's bureaucracy doing it, rather than the Australian Industrial Relations Commission with the flexibilities they had and the discretion they had. One person is sitting in the bureaucracy ticking off the boxes, whereas the Commission looked at it and said, in the tribunal or during the hearing, how does that apply, Mr. Tamplin? And you would give an explanation that would be recorded in transcript and used at a later date and relied upon at a later date.
But essentially, the old system got things done and the new system
doesn't.
doesn't it? So, that's workplace agreements.
Well, it's a shame, actually, because it's so necessary for the economy and for the country.
You heard it from John Tamplin here at the Edge at Edgecliff Serviced Offices in Edgecliff.